Collaborative law is an improvement on the legal process involved in a divorce and a separation. Parties to a divorce and separation will have their own attorneys and will meet in informal settlement conferences over a period of time and resolve all issues between them, including child custody issues, in a non-adversarial and rational, productive way. Collaborative law works when both parties have collaborative attorneys and they meet in a series of four-way settlement conferences. Oftentimes other professionals are utilized, such as a neutral financial person or child specialists that will help resolve separate issues that normally would go to the court for determination. Collaborative law uses the most qualified, most affordable professional to resolve a particular aspect of a dispute between a husband and wife. For example, oftentimes a neutral financial person will be utilized to help in apportioning marital property and to deal with alimony and other support issues. Child specialists also work with parents to help come up with a parenting plan that meets the future needs of the family. Collaborative law is not just like mediation. Mediation will occur oftentimes in the middle of a contested litigation in the family court. Collaborative law happens before litigation happens, and the parties don't go to court until all issues are resolved. Collaborative law does not limit your options. In fact, collaborative law will expand your options. In a traditional case, when litigation is involved, attorneys have to try to settle the case while at the same time preparing for litigation. What this means is that all information obtained by attorneys while they're trying to settle a case is also being used behind the scenes to prepare for war in the family court. This is extremely limiting to the parties' ability to resolve cases. With collaborative law, since the parties are not going to go to court until all issues are resolved, it is much more flexible and is a much more creative process for resolving all issues. I believe that collaborative practice is appropriate for probably 90% of all cases in the family courts right now. I think that everybody should consider the collaborative process before they embark on litigation. I have found cases that involve serious mental health issues and also domestic violence oftentimes are not appropriate for collaborative practice. Both attorneys need to be trained in collaborative law in order to engage in a collaborative practice case. Both attorneys are going to need to go through a 2-day collaborative practice training, as well as being certified family court mediators in South Carolina. I have found the best way to begin the collaborative law process is to make a commitment to do collaborative law and retain a collaborative attorney. That attorney will then notify your spouse, or you can notify your spouse individually if you'd like. And that spouse can then go retain their own collaborative attorney, and the two attorneys will talk and begin the process.